as a judge tossed out Manafort's civil lawsuit to challenge the authority of the special counsel Robert Mueller, writing in a 24-page ruling that a civil case is not the appropriate vehicle for taking issue with what a prosecutor has done in the past or where he might be headed in the future. Manafort, a man who is wearing an ankle bracelet on each leg, will have to face a bevy of existing charges in his first of 2 public trials beginning in July, unless he flips. Help figure out what this all means for Manafort, I'm joined by former U.S. Attorney from Northern District of Alabama, Joyce Vance, former U.S. Attorney for the Western District of Pennsylvania, Harry Litman, and former federal prosecutor Renato Mariotti. Joyce, let me start with you. The judge's ruling today, what's your takeaway from that?
It's the correct ruling. In a criminal case, there are a variety of mechanisms for a defendant to judge the validity of the lawsuit. He can file a motion to dismiss. He can challenge jurisdiction. What Manafort did was to go outside the confines of the criminal case and to file a separate civil lawsuit. He tried to challenge Mueller's legitimacy, really, as a special counsel in that lawsuit, and the judge properly dismissed that.
Renato, right now it seems like the path is cleared for a trial sometime in the fall. What would that trial look like?
Well, it would be it would be a lengthy trial. There would be many, many witnesses, a lot of documents and records. There are many cases, there are many charges against Manafort, complex charges like money laundering, for example, charges relating to his disclosure of various bank records. So you would literally have witnesses coming in from various, entities talking about how their records are kept, talking about his, where he kept his bank accounts, for example. You'd have his associates talking about how he ran his operation. His lobbying efforts, for example, and what he was doing there. So it would be a pretty lengthy trial that would focus on some arcane financial transactions.
Harry, there's also some developments happening in the Michael Cohen seizure that happened in the Southern District of New York. He was raided by the FBI. His lawyers and the president's lawyers teamed up to say that the government shouldn't be able to review the files and sort out the privileged from the non-privileged. Today, a federal judge appointed what's called a special master to review material seized from Trump lawyer Michael Cohen. What does that mean?
It means it's an officer of the court, so somebody who works neither for Trump Cohen nor for the government, who will be communicating with the parties to review the documents in the first instance and try to call out which are privileged, which seem to have indicia of advice from a lawyer, which we're told by the United States are fairly few. They expect and have represented to the court that Cohen really wasn't so much a lawyer as a kind of businessman fix-it guy. And if they're right, there won't be that many documents that the special master will identify. But the special master will have the first, she'll have the first crack at it and will report to the court in the collaboration with the parties.
And Joyce, it seems like the president agreed. I mean, yesterday on Fox and Friends, he said there's not that much there because he said he's barely represented me as a lawyer.
Yeah, that's exactly what he said, and it's really interesting, Chris, because originally there was some equivocation. Was Cohen acting as a lawyer? Was it just a business deal? But the president put that to rest, saying that on this one small piece, at least on this Stormy Daniels mess, the president said that Cohen was acting as his lawyer. And that opens a whole host of questions, because we know that that $130,000 payment was made very clear to the election, was probably made to influence the election. And so there will be an inquiry, possibly in the Southern District of New York, into whether that payment violated campaign finance law, either as an illegal contribution or because it was an unreported payment. A lot more shoes to drop on this one.
And then meanwhile, Michael Cohen, who's got a whole bunch of different legal issues he's got to deal with, he's got the civil suit from Michael Avenatti. He's representing Stormy Daniels. Now, today he got what appears to be a win. The court finds there is a large potential factual overlap between the civil and criminal proceedings that would heavily implicate Mr. Cohen's Fifth Amendment rights, granting a 90-day stay, basically a pause in the civil suit being brought by Avenatti against Cohen. Renato, what's that mean?
Well, when somebody has a criminal investigation and a civil lawsuit about the same matter going on at the same time, judges try to weigh the prejudice against, in this case, Michael Cohen with the prejudice to Stormy Daniels. So, for instance, Michael Cohen has a constitutional right to take the Fifth. He ordinarily would be doing that in the criminal investigation. But in the civil lawsuit, in the suit by Stormy Daniels, if he took the Fifth, that could be used against him. The jury or the judge could assume that the answers to his questions would have hurt him. So going forward with the Stormy Daniels lawsuit would have put him in a pickle. And that's why the judge weighed that versus the harm to Stormy Daniels, which, frankly, she's telling her story on TV, and her lawyer is all the time. So, you know, there was not much of a harm on her end of the equation.
Michael Avenatti, the lawyer there, is quite a character, and his Twitter feed I recommend you, which every post ends in #basta, which means stop in Italian. Harry, it seems to me that one of the subtexts of the judicial rulings in the civil case against Michael Cohen is this dude's going to get indicted. Like that is very much between the lines. My sense from reading what the judge in that civil suit say.
That's not the subtext. That's the text. Right. Judge Otero says, I think an indictment is coming. And, you know, something that's really telling about both the Otero opinion and the Berman opinion, as Joyce says, the Berman opinion was very straightforward. No way Manafort could win that. And as Renato says, this was the right call also in the Cohen case. Yet both of these judges were extremely comprehensive and thorough. Berman, this 24-page opinion, as you say, and Otero saying an indictment is likely. It's the president's attorney. There's real consciousness on the part of both these judges that what could otherwise look like pretty pedestrian matters are, in fact, really freighted with history almost, but certainly consequence because of the Trump overlay.
Did it read the same to you, Joyce?
It did. I think Harry's analysis is exactly right. Neither one of these rulings was a surprise. They were both pretty straightforward matters of law. But the judges do understand that these lawsuits are going to shape the course of history in a significant way. They were very careful, and it's important to note that Judge Berman was very clear that although she was ruling in the civil case, that the civil case wasn't the correct vehicle for this decision to be made, she wasn't in any way intimating what her ruling would be in the criminal motions challenging Mueller's ability to indict Manafort. That's still to come.
You know, in both of these rulings and in all of the stuff I've been parsing, it's like you can see the shadow of the shoes yet to drop sort of cast over the entire proceedings. It's really, really ominous in the language. Joyce Vance, Harry Litman, and Renato Mariani, thanks for making time.
Thank you, Chris.
All right, Paul Ryan makes history, firing the chaplain of the House. The